Entrepreneurs, today we're going to talk about a topic that we do not discuss enough, not only on this episode, but as entrepreneurs ourselves within our own companies. We're sitting down today with James Mulhern from Mulhern Law Firm, and we're talking about trusts, the different phases from revocable trust to really passing on your legacy in phase 2 and phase 3. We talk about the difference between a will and a revocable trust, the difference between a revocable trust and an irrevocable trust, why entrepreneurs and businesses need to have buy-sell agreements, and how you can really start planning today for wealth preservation for you and your family. Here's James Mulhern. James, welcome to the Entrepreneurs United podcast. You hit both sides of the border. McGill graduate, a Harvard graduate. So you hit my hometown of Montreal, then back in this Boston market. You practice now law in the greater Boston market area. Can you tell our audience a little bit more about what exactly you do and your practice does today?
Absolutely. Well, first of all, thank you, John and Rich, for having me on today. Looking forward to the conversation. And as much as I love Cambridge, Montreal always has my heart. So I'm glad we have that in common, John.
Yes.
I work at a boutique law firm here in Portsmouth, New Hampshire. So as you say, kind of the greater Boston area. We are a boutique firm. We're also a family firm. So the two founding partners are my two parents, David and Sally Mulhern. And I'm the new kid on the block, having joined at the end of 2020 after graduating from law school. And we focus the practice on all things trusts and estates. So we do both the planning side, helping individuals and families, and occasionally even entrepreneurs, plan out what they want in terms of their testamentary wishes. And then on the other end, helping to implement those wishes after people pass away. So we really cover the lifespan and the after lifespan of our clients and try to serve both the local community here. We're licensed to practice in Maine, New Hampshire, and Massachusetts. So we service sort of the local community in all of their needs along those dimensions. And then we also help people across the country with what I would call more sophisticated strategies as well when it comes to wealth preservation and maximization of transfer in a tax efficient manner to the next generation.
Got it. And, certainly we spend a lot of time, Rich and I, on this podcast talking to, professionals in a whole bunch of different degrees. Rich, I don't think we've ever had, an attorney talking about estate planning on our podcast. And I think it's a really important one because you spend all these blood, sweat, and tears growing your business. And, once you do grow it, at some point you hope to exit or you hope to take some wealth from that creation that you've had, or it may either be over time, annual income you're taking and you're putting somewhere, or you're probably raising a family at the same time. You have a lot of things that start accumulating and you just never know what can happen, when, where, how, what. When you say sophisticated wealth preservation and planning, can you give me some examples of what you're talking about there?
Yeah, absolutely. Maybe I'll back up just a step from the most sophisticated out there and kind of give a lay of the land. We think about this often in multiple, what we internally call phases. So there's a whole phase 1, which I would call kind of core estate planning, which is a necessity for everybody. Really anybody from people who just turned 18, come into the office and set up basic documents, making sure that if, something happens while they're away at college, their parents can sign off on medical orders, through to new families and making sure that you're appointing guardians for any minor children and expressing your wishes around that. And all the way up to, setting up a revocable trust, making sure that you are ensuring not so much tax efficiency, but efficiency more broadly defined when you pass away. Something that I do think is important for entrepreneurs, making sure that they have a plan set up so that when they pass away, any business is able to be conducted sort of in a continuous fashion without a big break because courts and judges get involved. And there are all sorts of things that we want to have in place, kind of nuts and bolts there. I think what you're asking though, John, is, okay, I've done that. I have kind of my core plan in place. What's next? What are some of the cool things I can do? Mm-hmm. This is what we would call phase 2.
Okay.
And phase 2 is fun. I'll start off with the caveat that phase 2 is always a little bit different based on the individual, based on the family, based on the business, et cetera, go on down the list. There's no cookie cutter solutions here, which is part of the reason it's fun. But in general, the exercise of phase 2 is to take the amount that any individual can pass on to the next generation free of tax, free of estate tax, which is currently fairly high. It's currently almost $25 million for a married couple. To take that $25 million or whatever the amount may be and try to squeeze through as many dollars as we can through that $25 million hole. There are all sorts of ways we do that with trust strategies, with gifting strategies, with various things I'm happy to get into.
Okay. And is there a phase 3?
There is. Phase 3 tends to be what I would call kind of legacy planning. Once you're really at the other end of that $25 million and you start to think about, okay, I have enough, my kids, my grandkids, as far down as I can sort of envision in my family lineage here, everyone's going to be all set. Now I want to think about charity. Now I want to think about family foundations, various charitable trust strategies.
Got it.
And that's interesting and exciting for other reasons.
Okay, got it. Now, I guess to bring up kind of the phases here and when you start thinking about them, it's very clear that phase 1, everybody should be thinking about it all the time from the moment you become an independent student to new family and you move forward. When should you start thinking about phase 2? An entrepreneur may be listening to this going, well, my business isn't quite there yet. Maybe I don't have to worry about that right now. Or do they start, when should they really start thinking about this phase 2 where they're trying to pass on to the next generation? Because a lot of people don't like to think about the fact they may not be here and have to pass stuff on. So they delay that. But at what phase should they be thinking about phase 2?
Yeah, that's a great question. And you're absolutely right. This is part of the constant tension with all of this is making sure that at the end of the day, there are all sorts of wonderful tax strategies that I can lay out. But at the end of the day, I want to make sure that the individual who created this wealth is invested blood, sweat, and tears in the business, still maintains a level of control that he or she is comfortable with. So there's always that tension that exists no matter what you're doing when you're thinking about transferring these assets. But your question's a good one in particular because it really never hurts to start thinking about these issues early on. If we're going back to my example of trying to squeeze as many dollars as we can through that $25 million hole, if we can do that while the assets are still relatively low in value, it becomes a lot easier. We can start moving assets out to next generation, or there are other ways that you can even maintain some level of control. If we can in some way start providing some distance between you and those assets prior to a large explosion in the value of those assets, that's really when the estate planning attorney starts to salivate. I mean, that's where all the opportunity lies, is passing these assets on prior to that explosion in value. And one sort of visual that I find helpful with this is thinking about the acorn and the oak. This is kind of a classic example that you'll hear people bring up in this area. I have this acorn, it could grow into something. If you can set it up in such a way so that the tree grows in a tax efficient way, that's great. Once the tree is already there, it's a lot harder to dig up the soil and move it. But if we can nimbly move around the acorn, there are all sorts of options available.
Gotcha. So a couple of things on this one, because I think it's pretty relevant. If I understand correctly, right now, a married couple can pass on up to $25 million tax-free to anybody, their heirs or anybody else.
Correct.
And I think what you're saying is in phase 2, the earlier you start thinking about it, there's probably 2 benefits, right? One is you can start directing things into this pocket that may have a value of $10 today, but may grow to appreciate to be worth $10 million, but it only counts $10 against your $25 million.
That's exactly
so you can
right. Yeah.
More of that before it explodes. And is the other side of the coin too that what today is $25 million per couple may become $15 million per couple, which may become $10 million per couple or whatever, just because the economy needs more tax dollars?
Yeah, absolutely. This is a historically unprecedented time to be talking about $25 million. That's just out of the realm of where it's been historically, and much closer to kind of the $1 million range up until just the last couple of decades. It's actually scheduled to sunset down to 50% of where it is now. It's inflation adjusted, so call it approximately 6 million starting in 2026.
Wow.
So most folks don't have plans to die over the next couple of years. So that headline number is very high for now, but you're absolutely right, John, that it's already scheduled to go down in just the next couple of years. And I always say this is a very politically salient number too, other than maybe the top marginal income tax rate and the capital gains rate. In some sense, I think this is sort of the third biggest headline number that just has a lot of political weight when it comes to campaigns, when it comes to, reaching out and appealing to certain constituents. It's always in the crosshairs for that reason. So absolutely, there's an opportunity right now today to lock in that $25 million in a way that protects against potential legislative changes in the same way that you're protecting against large explosions in value.
So tell me about, James, if someone doesn't do phase one and they've got, let's say, if I go online, I look at what's a typical nest egg for retirement, I'll probably see something that says between $2 and $3 million, and then you live off of 4% of that, and you're good to go. So if, let's say, somebody has $2 or $3 million, and they don't do phase one, why does that matter? Like, what is the consequence that they're going to experience if they don't do at least phase one?
Everything we're talking about here applies at death. But when it comes to phase one, we actually are planning for also incapacity. So a period of time before you actually die when you might need some support. So the parade of horribles starts at the time that you become incapacitated or could become incapacitated if you have no plan. So without a plan, you need to have a judge involved to appoint various people who can step into your shoes, be that a guardian, or it goes by various names depending on the jurisdiction. Somebody who can step in and say, okay, yes, now I'm going to start paying Rich's bills, and I'm responsible for making decisions around Rich's medical care, whether or not he needs nursing home care, et cetera, et cetera. So a judge needs to get involved and appoint somebody on your behalf rather than you being able to speak for yourself in these documents and dictate the terms of what happens when you become incapacitated. So that's kind of step one. And I think that applies throughout. The trend here is that if you don't say anything, a judge is going to have to say something. So if you do no phase one planning when you die, everybody actually has an estate plan by default. Every state has what's called the laws of intestacy, meaning that you died without a will or a trust stating your wishes around what will happen with your assets. So what happens is a probate court case is opened and they apply the rules of intestacy, which are designed to sort of guess at what a typical person would want with their assets, but it's not always perfect. And it certainly is no substitute for somebody actually just stating what they want in estate planning documents properly drafted. The biggest thing here, though, is not so much if I do nothing. I think the biggest thing is if somebody relies on what I would call a will-based plan versus sets up a revocable trust. So a revocable trust is an instrument for avoiding probate. So it's another way of getting the judge not involved in the settlement of your affairs. It's particularly important, I think, in this context, because probate is just a lengthy process, and it's a process that involves that level of oversight by the courts. And when it comes to somebody who has complex business interests, it's particularly ill-suited to going through a process where everything needs to be constantly valued and appraised, and you need judicial sign-off on everything you want to do. That's not going to work if you have, a bank loan that needs to be taken out or a buy-sell agreement that needs to be implemented on a rapid basis. It just can't respond to actual business needs in the same way that a flexible revocable trust can. So I would say from the business owner's perspective, the most important thing here is making sure that you have the ability to continue to run the business in the same way that you did the day before the person died as you can the day after they die.
Number one is if you're incapacitated and you don't do phase one, what's going to happen is a judge is going to appoint someone who will be responsible for your medical and financial decisions. Versus
Correct.
If you did phase one, you would be able to appoint that. Do I have
Correct.
that part clear?
Absolutely crystal.
Okay. Then we move on to death is the other planning piece, which if you do not do phase one, a judge is going to apply the rules of intestacy, which is basically trying to use logic and common sense on where things should go, versus your other alternatives are a will or a revocable trust. Am I clear so far?
Crystal again.
Okay. I know you started to go down that road, but I'm not able to validate with clarity. And my assumption is if I can't, maybe our listeners can't. So can you, with clarity, define the value of a will versus the value of a revocable trust? You were starting to go down that road, but I'm not super clear.
Sure. So a revocable trust is really a will substitute. So you kind of have two paths that you can go down. You can go down the will path or the revocable trust path. The only real difference between the two paths is that one involves the probate court and one is private. The will involves putting the will before the court, having somebody appointed through the court as the executor to settle the person's estate. There are various boxes that need to be checked along the way in terms of potentially posting bond, but things like accounting, making sure that various notices are given to individuals. On the other hand, when it comes to the trust, it's really a choose your own adventure. You can appoint what's called a successor trustee within the trust. That successor trustee does not have to go ask a judge to perform all of the same sets of actions that you could imagine would need to be performed when somebody dies. Be that figuring out what assets the person owns, selling assets, making actual distributions to the ultimate beneficiaries. All of that happens privately without a judge being involved in the trust world, versus in the will world, everything is sort of going down this very sometimes cumbersome path.
All right, let me take a shot. The will is you're naming someone, but that someone has to be put in front of the court to be able to make decisions. Versus a revocable trust, you're naming someone who is able to make decisions in the absence of the necessity of a court.
Absolutely, yep.
So why would anybody ever want a will?
We had the same question, John. Why would anybody want a will in that case?
I will say that most estate planning practitioners, it's a rare bird where you recommend a will. I can give you an example of one that I did recently. Married couple, sort of worked for the majority of their lives, didn't have very complex assets. A lot of it was in retirement accounts. They owned a home, but everything was going to charity. And in that case, okay, so maybe it takes a little bit longer, maybe it's a little bit more cumbersome, but there's no business that needs to continue to be run. There's no real estate in 6 different states, relatively streamlined already. And even if it does take a little bit longer, no problem. It's all going to this charity at the end of the day anyway. So that would be an example. Another example is typically when people are very young, putting something just sort of very basic in place, not having to have a trust that requires a little bit more ongoing maintenance. But in the main, for most folks who have achieved a level of assets and a level of sophistication in those assets, the revocable trust becomes somewhat of a no-brainer.
I've also heard of an irrevocable trust. What is that, and why are you choosing to juxtapose will and revocable and leaving out irrevocable to come back to, like, it sounds like the core recommendation is revocable. So can you define irrevocable and why maybe to not use that option?
So the irrevocable trust is a wonderful option for all sorts of things. And it really interacts a little bit more with that phase 2 that we were speaking about a little bit earlier. When it comes to sort of why am I putting the revocable up again? Why am I pitting that against the will? The answer is really because it functions in the same role as a will. It defines what happens when you die, but you have flexibility to change that while you're alive. Irrevocable trust is sort of what I sometimes call a real trust. It's a trust that the terms are settled, what's called the corpus, the assets that are in the trust are defined. There is a trustee who sits in one role. There are beneficiaries who sit in another role. The trustee is tasked with various responsibilities for how they behave and how they make distributions to the beneficiaries. It's kind of the real deal trust as opposed to a trust in name, but really a will substitute. When it comes to why you might use an irrevocable trust, there are all sorts of reasons. Some of the traditional reasons might be you're thinking about passing or giving money to somebody who just sort of, for whatever reason, is unable to handle that money. Maybe they're too young. Maybe they have a drug problem. Maybe they're too old. You want to be able to separate out the person enjoying the property and benefiting from whatever's in the trust from the responsibility associated with managing that property. Kind of a classic reason. Beyond that, irrevocable trusts have built up a lot of utility when it comes to tax planning, when it comes to creditor protection, keeping a little bit of distance from assets so the creditors can't attach it. And in that world, that's mostly the world that I live in when it comes to thinking about use of irrevocable trusts in estate planning. So if we go back maybe to one of the things we were speaking about before, we're talking about cutting the $25 million check and giving it away today and putting it into a trust as opposed to giving it outright to somebody. Doing that brings with it all sorts of advantages. So we think about now gifting things away during life into an irrevocable trust. By doing that, you get all the advantages I was just speaking of. Maybe you want to give it to your kids. Maybe your kids are young. Maybe you want to give it to your grandkids. Maybe your grandkids are young. You get other benefits as well. On the tax side, there are ways to structure these trusts as so-called dynasty trusts or intergenerational trusts. You can set them up in such a way so that not only are they not subject to estate tax when you die, but they're also not subject to estate tax when your kids die, when your grandkids die, all down. I sometimes think of it as the fire pole as opposed to the steps. You take the steps, you're getting chopped down at 40% estate tax each year. Once you get on the fire pole, you're sliding down the generations without taxation. I think one big thing that comes to mind, particularly with people who are entrepreneurial minded, who are clients, is not so much on the tax side, which I'm happy to speak, talk your ear off on that if you're interested. Few are, but is the creditor protection piece as well. By having these assets in a trust, almost every jurisdiction, if not every, allows for setting up these trusts in such a way that they are not subject to the beneficiary's creditors. So if I make a gift to my kids, I put them in a trust, I have proper language in the trust. My child goes out and becomes a doctor and has a malpractice lawsuit against him or her, this money is safe. My child goes off and gets divorced, this money is safe. So being able to build a bunker like this for wealth preservation for multi-generations, while at the same time making sure that the tax authorities and potential creditors are kept as far away as we can.
So I think I got that. The irrevocable trust, the terms are non-negotiable. You can't change your mind. That's why it's irrevocable. The assets are defined. You can't change it. The beneficiaries are named. You don't change it. The distribution of the beneficiaries are named. Because of that is why you had mentioned you avoid the 40% estate tax. So for example, I could say my grandchildren's grandchildren are going to get $10,000. And because it's still attached to my irrevocable trust, it doesn't have to pass through my kids to my grandchildren losing 40% each year. It's immediately hotwired to my grandchildren's grandchildren, who is my intended beneficiary. So you can avoid multi-generational estate tax by making it irrevocable because it ties back to the original person who set up that irrevocable trust. The other one is it's protected from lawsuits because you can't say, hey, we're going to sue you for that irrevocable trust that was set up by your grandfather's grandfather. Like, you can't do that. Like, it's in a trust. And that is a tool that is typically used in phase 2, because that's where you can really start to hone in on defining the assets. The asset often is the business or an amount of cash in the business that can be placed there, which is why that's really a tool for phase 2. And you didn't mention it in phase 1. How did I do there?
Perfect. a little bit of nuance on exactly what an irrevocable trust is. I think sometimes people get the impression that this thing is really locked up, never subject to change. And that's something that, as we start to have more trusts designed in this way, this dynasty trust, this multi-generational, designed to be around for hundreds and hundreds of years type of trust, that starts to be a pretty scary concept, right? I've locked this thing up. I've put terms in that made sense in 2022, but let me tell you, if you looked at a trust that was set up in 1722 today, it wouldn't make any sense at all. So what's the room for flexibility in terms of changing these documents? And the answer is there is some. So I don't want to give the impression that it's locked in there, and no matter how little sense that trust structure starts to make in the future, you can never possibly sort of update the terms or make any logical changes. There are some possibilities for doing that. And beyond that, I guess the other thing I would add is, it's probably my fault before. I was saying before that the assets are defined. You can always add, well, not always, but it's quite often the case that you can add to irrevocable trusts. So you have like an initial set of assets that are defined in the trust, but you can at times, with some caveats, add assets as well.
Gotcha.
But beyond that, that's exactly right. You do some planning now. By doing so, you put it into this structure that provides for that sliding down the generations, and does so in a way that keeps sufficient distance between the beneficiaries and the assets that people who want to sue the beneficiaries can't get to that money.
And I think on the assets defined, what you clarify, there are conditions by which you can add, but you cannot withdraw. You cannot take assets out of an irrevocable trust.
Exactly.
Okay.
That's what I was trying to get to before, but I realized I didn't quite say it the right way. So
yeah, I'm clear. That's great. Very good education. Thanks for that.
Yeah, and Rich, great job catching all that, because these aren't easy concepts. It struck me as you were talking about passing money to beneficiaries without, the beneficiaries having responsibility because they got some things going on. Is this the Britney Spears have irrevocable trust? Was that an irrevocable trust where her father was governing it and then he got booted from it?
I think she was subject to a conservatorship, if I'm not mistaken.
That's what it was. That's a different story altogether.
I'm sure she has a trust too, though.
I'm sure. So, I really want to ask this question here. And I'll use the example Rich gave. This wouldn't be Rich allocating $10,000 to his grandchildren's grandchildren, as much as it would be, maybe it's $10,000 today, but the trust would do something with that $10,000 that in 100 years from now, that $10,000 may be worth gosh knows what. That's the tree growing underneath this umbrella in perpetuity, right? And I think that's kind of what you're saying when you talk about, hey, you can gift during your lifetime that may have generational benefits tax-free throughout. Is that right?
Absolutely the case. Yeah.
Okay.
And certainly, just to add, just to make sure that put a little finer point on it, certainly this money would be, even if it was not wrapped up in a business, it doesn't sit in a checking account, still obviously being invested for growth, regardless of the sort of initial composition of the assets.
Exactly. Okay. And I have a few more questions on that related to how that exactly works. But before I get there, what percentage, and off the cuff, obviously, I don't expect you to know the exact percentage here. What percentage of entrepreneurs have irrevocable trusts and are thinking about phase 2, in your opinion?
That's a great question.
We're not going to hold you to the legal answer, James. What's a ballpark?
I don't know that I have a percentage or a number. I can put it in monetary terms. That's probably the closest I can get.
Okay.
I would say that anybody who is above a net worth of, say, $5 million,
mm-hmm.
or anybody who has the expectation that they might end up with a business asset that could be worth, say, more than $20 million, even if currently it's much less than that. I would call those sort of rough triggers for where I would start thinking about this.
Okay. So if I'm listening to this episode and I'm like, okay, look, like I'm at the startup business phase, I don't need to worry about phase 2. But if I'm at the point where, look, my business someday may be worth a total of $20 million, or my piece of the business, or my net worth in total, if I was to sell this business or move on, it's probably over 5. I should be having this conversation right now about how I can get in. into this irrevocable trust. And specifically, you said, how do you lock in the 25 million? You had said something earlier, like doing it sooner rather than later is good because it may go from 25 million down to 6 million. And now, the window is shut down. Your tree can't grow as much.
Yep.
How do you, let's say I'm an entrepreneur. Okay, I fit the criteria. I want to look into this now. What are some ways to take advantage of locking in the 25 before it changes?
Sure. So to answer your question directly, I would say the number one strategy that's currently in use for this specific issue of making sure that we can maximize the amount that we can pass on today and not wait until the laws change is through gifting.
Okay.
So providing a gift, often to a trust rather than outright, for all the benefits that we were just talking about, taxes and creditor protection. And doing that now with some clarification from the IRS in the last couple of years that there's not going to be a so-called clawback, that money will eventually be due tax when the amount comes down in the future.
Okay.
There's some pretty solid assurances that anything you give away today is safe. So therefore, people who have the ability to do that today are doing that, and they're doing it to trusts. And I think I want to add a little bit of, now that we've kind of laid a lot of the groundwork, and these are tricky concepts, so I don't want to go too far out, onto the twigs without explaining the trunk and the branches.
Sure.
But a couple ways to sort of lever this up even further. So when I say a trust, we're now in the irrevocable trust world. So we're talking about really giving it away to a trust. Now you've created some distance between me, the person who created the trust, so-called grantor, and the trust itself. Once that happens, there are ways that you can sort of get a little bit more juice out of that. Few examples. One is so-called minority discounting, so that when assets are being passed into this trust, there's often the opportunity to use existing business structures or even creation of new business structures to give away only a fractional interest in some sort of property and argue that because it was only a minority fraction, it's worth less than a proportional fraction of what the value is. So you give away 40%, but you say it's actually only worth 20% of the value. So that's a way that you can get a little bit more out of this.
Okay.
I think another key one that we use frequently is actually switching back to a different tax concept. It's an income tax concept around what happens. Now we set up this trust with $25 million in it. That thing's going to start spitting off large amounts of income as time goes on. And it's possible that some of that income will be accumulated in this trust and subject to tax, income tax, annual income tax within the trust itself. When that happens, there's an opportunity to create what's called a Grantor Trust. Grantor, again, being the person who created the trust. In some forms, these are called intentionally defective Grantor Trusts. And when people say intentionally defective, they basically mean the grantor intentionally makes it so that any tax due on the income in the trust is paid by the person who set up the trust rather than the trust itself.
Yep.
And when I say this initially, everybody always looks at me like, why would I ever want to pay more tax? That makes no sense. The answer is this tax is due either way. You got $25 million spitting off $1 million of tax every year. Somebody has to pay that $1 million.
Yep.
By having it come from the person who established the trust rather than come out of the trust, you allow the trust to grow tax-free on the one hand, and you reduce the potential money that's left over to be subject to estate tax when the person who set up the trust dies. You reduce that by an equal amount. So if you start doing this year over year, you can really lever up this gift and create a lot of opportunities. Again, back to that exercise, $25 million. How do I fit $100 million through that hole?
Yep.
This is one way to do that.
I love that. So let me pull a Rich here and make sure I fully got it. So when you talk about gifting, in the context you just gave, the minority discounting, one opportunity that's available to entrepreneurs is if they're setting up new businesses or currently have a business, they could gift, let's call it 10% of their ownership to an irrevocable trust where the trustee is somebody they trust, as an example, whether it be a spouse or an attorney like yourselves, right? Where that 10% ownership is discounted. So if the company, for lack of a better example, the company's worth $10 million, you would argue 10% is worth 1 million, but because of minority discounting, that 1 million may be worth 500,000 instead of $1 million. And you can gift it at a $500,000 value, even though that company is going to continue to grow and at some point maybe worth a lot more money. You get the minority discount. Is that correct?
Mm-hmm.
Okay.
I want to take a quick pause there.
Yeah.
My first question was going to be, is that legal? And my assumption is the answer is yes. And my assumption is the answer is yes, because the value of something is disputable until it's sold. Is it legal? And is that why it's legal? So you can believe you could sell something for $10 million, but you don't know until it's actually sold. So it's not actually sold. So instead of claiming the $10 million, you can say, I'd turn around and sell it at $5 million. I don't know. It's not sold yet. We're going to call it $5 million.
It certainly it's legal. And I would say I might put it slightly differently than you did in terms of why. I would say there is a so-called discount for lack of marketability. In other words, the asset's illiquid, which is, I think, a version of this. But it's also just a discount because a 10% share doesn't have the same voting rights, doesn't have the same opportunity to influence the ways in which the business continues to operate. And that's the kind of economic theory on which a minority discount rests. It's really those two together.
True value is less than the 10% because it's reduced voting rights and all the privileges of ownership of a portion of a business are actually worth less than 10% when you look at the fact that it's still operating.
That's exactly right. Yep. The other thing I would say is when it comes to sort of legality, first of all, I won't be sharing any strategies that run too far afoul here.
I assumed. That's why I was like, is that legal? I'm like, it must be legal because he just said it.
Yeah. I think one thing that happens here at the outer edges, though, is you can get into instances where you are subject to audit risk, and the IRS might disagree with your minority interest. So you could trip up in the sense that you get too aggressive with this, and you say, okay, I want to apply a 90% discount to these shares because they're illiquid. The IRS could easily come back and take issue with that and argue for a different valuation, and then you have to duke it out with the IRS.
What makes sense, Rich, is if you and I own a company and I own 90% of it and you own 10% of it, well, you're never going to materialize your 10% unless I, as a 90% owner, decide to sell. And, there's other risks. The illiquid component of it kind of comes to play again in that particular situation. James, if someone was to buy a home, could they put 10% of the home in an irrevocable trust and 90% in a revocable trust? Or, actually just on that concept alone, when you buy a home or you buy new things, when should you start putting it into a revocable or irrevocable trust? At what stage does that decision start happening? Because I've heard before, you should put your house in a trust, or you should do it. Like, when do those decisions get made?
It's a great question. When it comes to the revocable trust, basically everything you own in the estate planner's ideal world is owned, either it's out of your name in an irrevocable trust or you own it in a revocable trust.
Everything.
So we were talking about avoiding probate before. You avoid probate only to the extent that actually assets are moved into the revocable trust during your life. So you can have the trust, but if you also own the house in your own name, I, John St. Pierre, own this house, that has to go through probate when you die. So there's an exercise of taking assets that you own and moving them into the revocable trust.
What's the cost of probate, James?
I'm sorry, what was that?
Why do I care that it goes through probate? What's the cost of it going through probate?
Time, potentially dollars and cents cost, and for some people, privacy as well.
Okay.
But I think in this context, what I would point to the most is the time. It takes. We're in a situation now with the courts and COVID where it can be 6 to 9 months before you're even authorized by the court to go take action on behalf of the deceased person. And that 6 to 9 month delay is just unacceptable to many people based on businesses that need to be run or bills that need to be paid, etc.
Got it.
So James, did I catch that right? That you said, almost everything you buy should be in a trust? what should be in my own name versus my revocable or irrevocable trust? Like, is there anything I would buy? I mean, other than clothes and food, but is there anything materially asset wise that should not be in a?
So if John had a pontoon boat, if he had anything that has a title, should all of that be purchased in the name of the trust?
So we advise yes. I would say that's not the case for every estate planner. There's some difference of opinion on this. I think that difference of opinion largely boils down to the state in which you practice and how modernized their probate process is. In some states, it's not so bad. In some states, it's quite bad. I won't speak to which of the 3 states that I practice in that is maybe better or worse, but there's more urgency in some states than other. And in an ideal world, yes, the boats are in the Rev Trust, the house is in the Rev Trust, the cars are in the Rev Trust. I suppose the big exception to this that I should point out is retirement accounts. Retirement accounts sort of continue down on their own track. IRAs, 401ks, 403bs, whatever the case may be. You don't want to move those into a trust because you lose the tax benefits associated with having them in your own name. It's treated as a withdrawal.
Yep. This is another side question, not related to trust. All of a sudden, I'm going to go completely off trust, but I'm not going too far from the farm. Buy-sell agreements. I'm astonished at how many businesses have operating agreements, but not buy-sell agreements. Mm-hmm. Do you run into that same scenario?
Yes, quite frequently. We advise on buy-sells all the time. It's probably we do have some work that I would say sort of extends off from the core estate planning just because you end up being the family lawyer or the business lawyer or whatever the case may be. Probably the number one thing we jump in and help on is buy-sells. And yeah, people just haven't thought about it. They have a business to run. They've got employees to pay, payroll to make. They have rent that they have to pay. They're thinking about expansion. They're not thinking about, hey, what happens if my 40-year-old partner dies tomorrow?
Yeah.
But it's a necessity. And it's something that every business owner should be thinking about in terms of valuation, in terms of where the liquidity is going to come from on down the line.
Yeah, absolutely. Well, this is a topic, I guess, one of the reasons I was so excited to bring you on board, that sometimes you really have to sit down and really think through. I mean, Rich, I think you did a phenomenal job getting clarity on all these pieces. And it's just so important because we like to push to the back burner, right? It's kind of like, I'm fine, I'm healthy, nothing's going to happen. But what I got from this is, look, everybody needs to be in phase 1. And by the way, anybody should probably be buying all of their assets in a revocable trust, and think about that. And when you start approaching maybe a phase 2 of the net worth getting up there, or maybe your business assets could be worth it, starting to gift during your lifetime to get into this, gift exemption area, and start maybe thinking about an irrevocable trust or gifting your business. All these different pieces are things we need to talk more about. So I really love, what you've brought here in terms of clarity, in terms of how these different programs work. And to your point, there's a lot more devil in the details kind of situation here. But, it's a very good overview of what entrepreneurs should be thinking about as they move forward. I got one last question for you. What is one mistake you see people that are building wealth, it doesn't matter how they're doing it, do or don't do? What's the biggest mistake you've encountered in this area?
So when it comes to the core of what I do, I see all sorts of mistakes, but not funding a revocable trust is not, I think, a very interesting answer to your question. One thing that I see quite often is that people don't take advantage of all the ways in which they can protect themselves against liability. Too many things are owned in their own name. Too many things, we were just talking about buy, sell. You're sort of hoping that the worst doesn't come. And if it does, you don't really have a plan. They haven't, because it's not fun. They haven't thought about the worst case scenarios here and the set of tools that are available to them to create bunkers, to move things around in creative ways, to get not just efficient from a tax and business perspective, but efficient from a, let's guard what we've created. I think trusts are part of the arsenal that we have, but there's a whole set of tools available. And the worst case scenario is you just don't use those tools, and therefore everything you've built is contingent and subject to bad things happening. And my job is to steer you away from that.
Yeah, no doubt. James, if people want to learn more, how can they reach out to you and maybe talk more about these concepts?
Yeah, so visit the website, www.mulhernlaw.com, Mulhern. We have some info up there. We try to post updates around what's happening in the law, what's happening in the firm. Beyond that, we'd love to chat with anybody. As I say, we practice in the 3 sort of northern New England states, but we also take clients from all around the country, particularly when it comes to phase 2 planning.
Great. Thanks for your time.
All right. Thank you both.
Please stick around for a few more minutes while Rich and I break down this episode.
John, I had a rough idea on a number of these words and topics, but the way he described it really allowed me to grasp it and obviously validate it back in ways that he said, yep, you got it. I wouldn't have been able to get it that well had we not had him on as a guest. I think that was really beneficial for me personally, and I hope it is for our listeners as well.
Yeah, this was a very educational podcast. It's a very heavy topic, right? Thinking about what's going to happen when we pass. But I think, it all goes to, are you well surrounded as an entrepreneur, right? Do you have the right CPA looking at your taxes? Do you have the right corporate attorney looking at this? Do you have the right estate attorney looking at that? Do you have the right financial advisor for this? Having a well-surrounded team can really guide you through some of these steps to know when you should or shouldn't be doing things. I mean, I was caught a little bit off guard that everything I should be buying should be in a revocable trust. I never really thought about that. I do have a couple things in a revocable trust, but I haven't really started thinking that everything should be in it. But it's the preservation, he said, bunker down for the preservation of wealth within your family. You have the Rockefeller Trust, the Hilton Trust. There's all these different trusts of families that over the years have just preserved their generational wealth. And when you think about all that wealth being passed through tax-free and continues to earn in the investment vehicles that they're in, you can see what power that can have. Now, I'm not suggesting that we want our kids to be trust fund babies by any stretch of the imagination, but you could also do that with giving. You could give to a specific charity through your irrevocable trust. There's so many different things you can do that really preserves the wealth versus giving it to Uncle Sam at the end of the day. And the one thing, Rich, that I think is a really something I would double down on this statement that is critical. If you're a business owner today and you believe your business over time is going to grow, or there's going to be some sort of wealth creation in your business, this tax exemption of $25 million is going to come down. And it's going to come down rapid. I mean, you think about all the printing of money the government's been doing, and basically the debt that is loaded on this government right now. There's going to be a lot of pressure politically to tax people that have certain wealth numbers here in America, and maybe rightfully so. And so if you can contribute an asset that maybe is worth $1 million today, it might be worth $25 million in a few years, but it only accounted for $1 million of your exemption. That's the trick. That's getting something into the hole before it explodes, like you talked about.
I got to say, as a business owner, why wait to look into this stuff? Why wait until your business gets bigger? Why wait until you're sick? Why wait until there's a problem or some trigger? Like, there's no better time than the present. If you're still with us on this podcast, listening to this debrief, and you don't have a trust, I would challenge you to ask, why wait any longer? Let your investment in this time on this podcast propel you to do something about it and not wait until it's too late.